We need at this point to talk about Mapp versus Ohio. These are the facts. Miss Doll Ray Mapp, preferring to be called Dolly, and her daughter lived in Cleveland, Ohio. After receiving information that an individual wanted in connection with a recent bombing was hiding in Mapp's house, the Cleveland police knocked on her door and demanded entrance. Mapp called her attorney and subsequently refused to let the police in when they failed to produce a search warrant. After several hours of surveillance and the arrival of more officers, the police again sought entrance to the house. Although Mapp did not allow them to enter, they gained access by forcibly opening at least one door. Once the police were inside the house, Mapp confronted them and demanded to see their warrant. One of the officers held up a piece of paper claiming it was a search warrant. Mapp grabbed the paper, but an officer recovered it and handcuffed Mapp because she had been belligerent. Dragging Mapp upstairs, officers proceeded to search not only her room, but also her daughter's bedroom, the kitchen, dinette, living room, and basement. In the course of the basement search, police found a trunk containing, quote, lewd and lascivious, unquote, books, pictures, and photographs. As a result, Mapp was arrested for violating Ohio's criminal law prohibiting the possession of obscene materials. At trial, the court found her guilty of the violation based on the evidence presented by the police. When Mapp's attorney questioned the officers about the alleged warrant and asked for it to be produced, the police were unable or unwilling to do so. Nonetheless, Mapp was found guilty and sentenced to 1 to 7 years in the Ohio Women's Reformatory. Upon her conviction, Mapp appealed her case to the Supreme Court of Ohio. Her attorney argued that she should never have been brought to trial because the material evidence resulted from an illegal, warrantless search. Because the search was unlawful, he maintained, the evidence was illegally obtained and must also be excluded. In its ruling, the Supreme Court of Ohio recognized that a reasonable argument could be made that the conviction should be reversed because the methods employed to obtain the evidence were such as to offend a sense of justice. But the court also stated that the materials were admissible evidence. The court explained its rulings by differentiating between evidence that was peacefully seized from an inanimate object, the trunk, rather than forcibly seized from an individual. Based on this decision, Mapp's appeal was denied and her conviction upheld. Mapp appealed again to the Supreme Court of the United States. The case came down to this fundamental question. May evidence obtained through a search in violation of the Fourth Amendment be admissible in state criminal proceedings? The Fourth Amendment states the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, and particularly describing the place to be searched and the person or things to be seized. The Fourth Amendment, however, does not define when a search or seizure is unreasonable, nor does it specify how evidence obtained from an unreasonable search should be treated. While never previously addressing the specific question presented by Mapp's case, the Supreme Court of the United States had made attempts to determine what constitutes a reasonable search and what evidence can be used in court. It first wrestled with these issues in Boyd v. the United States in 1886, when the court declared that any forcible and compulsory extortion of a man's own private papers to be used as evidence to convict him of a crime is within the condemnation of the Fourth Amendment. Later, in Weeks v. the United States in 1914, the court ruled that the Fourth Amendment put the courts of the United States and federal officials under limitations and forever secured the people, their persons, houses, papers, and effects against all unreasonable searches and seizures. By including only United States and federal officials in its ruling, however, the court still left open the question of whether evidence unlawfully seized could be used in a state criminal proceeding. In Wolf v. Colorado in 1949, the court for the first time discussed the effect of the Fourth Amendment on the states. It concluded that the Due Process Clause of the 14th Amendment incorporated or made applicable to the states the Fourth Amendment to the Constitution. However, the ruling in Wolf also made clear that, quote, in a prosecution in a state court for a state crime, the 14th Amendment does not forbid the admission of evidence obtained by an unreasonable search and seizure, unquote. In other words, the exclusionary rule did not apply to the states. Some states, including Ohio, felt that they should be able to make their own determination regarding the admissibility of illegally obtained evidence. Nevertheless, in 1960, the Supreme Court of the United States agreed to hear Mapp's case and reconsidered the decision it had reached in Wolf by determining whether the U.S. Constitution prohibited state officials from using evidence obtained in violation of the Fourth Amendment. The decision in Mapp was handed down in 1961. The court brushed aside the First Amendment issue and declared that all evidence obtained by searches and seizures in violation of the Constitution is by the Fourth Amendment inadmissible in a state court. Mapp had been convicted on the basis of illegally obtained evidence. This was an historic and controversial decision. It placed the requirement of excluding illegally obtained evidence from a court at all levels of the government. The decision launched the court on a troubled course of determining how and when to apply the exclusionary rule. So, Dalry Mapp was no longer convicted. Now, positions have been taken relaxing the exclusionary rule. Some courts still claim that any evidence should be admissible. The exclusionary rule has become extremely technical to deter police misconduct effectively, and the rule is a vital safeguard for liberties. All of those things, opposition, pro and con, have been discussed about the exclusionary rule, and there are numerous cases involving it. Courts really began to adopt the second position in the latter part of the 20th century, allowing some exceptions to the rule. And the second position is, exclusionary rule has become too technical to deter police misconduct effectively. For example, police have greater freedom to question juveniles. There's limited coverage there. There's also the good faith exception. There's also, quote, overriding considerations of public safety, unquote, may justify questioning people without first reading them their rights. And lastly, evidence that would, quote, inevitably, unquote, have been found is admissible. So there are just some numerous technicalities. The next thing we have to look at really is search and seizure, because that's really where it all applies. Okay, so first you really have to acquaint yourself with the Search and Seizure Amendment. What can be a reasonable search of individuals? In other words, what does the Fourth Amendment protect? It protects persons, houses, papers, and effects. What does persons really mean? Well, what about a person's clothes? Yes. How about the wallet they're carrying? Yes. How about a person's blood or bodily fluid? Yes. Regarding houses, what about an apartment? Yes. Your front porch? Probably. A mobile home? Maybe, depending on whether it is being used as a home or a car. Regarding papers, what about a diary? Yes. A book in your house? Yes. Your email? Probably not. Your instant messaging text messages? Probably not. There's some new case law in that, so don't quote me on that one. Regarding effects, what about your backpack? Yes. All right. Your iPod? Yes. Your collection of comics? Yes. These questions of interpretation are the questions lawyers and judges argue over to determine the meaning of the Constitution. Should the protections of the Fourth Amendment be limited to just these four categories? Who does the Fourth Amendment really protect? It protects the right of the people, all those who live under protection of the Constitution. That includes citizens, that includes children under 18, and it also includes undocumented immigrants. What does the Fourth Amendment protect those people from? It protects them against unreasonable searches and seizures by the government. In determining what is an unreasonable search or seizure, courts look to balance individual liberty within the need to keep an ordered society. Figuring out what is reasonable or unreasonable is one of the central challenges of the Fourth Amendment. What does it mean to be seized? The key is that you are not free to leave where you are detained. If you can end the conversation and walk away, then you aren't seized. Or in the context of property, that you're not free to take your property back. Police put the cuffs on you, put you in a squad car, take you down to be booked. That's an easy one. But there are other ways that you can be seized. Police smash their car into your car as you're driving away. Police shoot you. And seizure applies to your property as well as to your person, freezing the money in your bank account, towing your car to the impound lot, etc. What about justified intrusions by the government? The second part of the Fourth Amendment talks about no warrant shall issue but upon probable cause. A warrant is a formal document signed by a judge that allows police to search or arrest you. Warrants allow law enforcement officers who have reason to suspect you, probable cause, to ask a judge for permission to interfere with your privacy. Thus, if a warrant is supported by enough specific information, the government can search you or your house or even arrest you. What does it mean to have probable cause? Well, probable cause means that the facts and circumstances would convince a reasonable person that a crime has been or is being committed. This is not enough proof to actually find someone guilty if they were charged with a crime and brought to trial. It's just enough proof to justify intruding on privacy to continue the investigation. How does this work in the setting of schools? Well, students do not give up all of their Fourth Amendment rights, but the courts have recognized a reduced burden on the government to justify search of a student's person or possessions at school. The Supreme Court set out the ground rules for when schools can search students in 1985 in a case called New Jersey v. TLO. In the TLO case, the Supreme Court said that a school can search a student's person or possessions if there is at least a reasonable suspicion that the student will have drugs or weapons or some other contraband items. And in that case, there was a reasonable suspicion for searching the student's purse for cigarettes because she and one of her friends were caught smoking in the bathroom. Reasonable suspicion is not the same as probable cause. You can have a reasonable suspicion even if you are not convinced there has been a crime committed. Reasonable suspicion means that a person in the police officer's position, knowing the information that is available to him, could reasonably believe that a crime has been committed or is about to be committed. It's not just a hunch. It has to be backed up by some evidence, but less than what you'd need for probable cause. Reasonable suspicion is also the standard if the police want to make a brief stop, like a traffic stop, where they detain you for a few minutes for questioning, but haven't yet placed you under arrest. The key question in a search of a student's person or belongings on school property will be reasonableness, and the keys to reasonableness are: is the item that the school is searching for something really dangerous? How reliable is the information? And how badly was the person's privacy invaded? So what is a reasonable expectation of privacy? Well, there are two parts to the analysis. First, do you actually expect privacy in your effects that you bring with you to school? The answer is usually yes. You expect to keep the things you want private to remain private. If you come to school with a closed and locked backpack, it is reasonable to think that you hope to keep the contents of the backpack from others. Would it be less reasonable if you carried the same things in a clear, see-through plastic bag? Probably. Second, is this expectation of privacy one that others agree is reasonable? This is usually the more difficult question. Does the largest society, in your case your class, agree that the medicine in your purse, for example, or religious materials in your wallet should remain private? Are there other interests government officials, administrators, teachers, police have in maintaining an orderly and safe school environment? For example, even if you wanted to keep the things private in your backpack, if there is a clear school rule that requires all bags and backpacks to be opened to search for weapons, your personal desire that things would remain private is not really a reasonable one. You know that it will be opened if the school just follows its rules. I need to do when the police can search without a warrant on part 3.